as if able.
Yes, Mr. Gates.
Thank you very much. So just one clarification point about the policy, then I'll move on to do some other things.
Yes.
As I explained before at lunch, the policy, the system used by the Secretary of State does not record the making of a delivery receipt request. It will only be recorded that there has been a confirmation of delivery if a request is made. And this was dealt with to at least some degree in the summary grounds of defence before the Upper Tribunal, paragraphs 10 to 16, which are at pages 63 to 65 of the core. Let me just briefly turn those up. So you see on page 63 when you get there, subheading relevant guidance, and the relevant guidance is then set out and addressed. Perhaps the key paragraphs within this are paragraphs 12 to 13, and 64, and then 14, and in particular 15 on 65. And I'd ask my lords to note the second sentence of paragraph 15, which has not been challenged.
What, the 50? Sorry.
1.5, page 65. So this is paragraph 15 of the summary grounds of defence.
This takes matters further because?
I don't think it takes matters very far forward, my lord, but I'm conscious that the court did put to me that there may be an inference arising in this case that supports my learned friend's case on the evidence, but because there is no record of the delivery receipt request being made, it could be inferred that the email was not received. The second sentence of paragraph 15 suggests that there's at least a possibility that a delivery can be made, and no delivery receipt is with a delivery receipt request, but the delivery receipt confirmation is not provided to the Secretary of State nonetheless, and that position has not been challenged by the Secretary of State.
You can't have it always. There's a perfectly easy technological solution to good administration. Your own guidance says what it is. You don't apparently keep records of whether you do it or not. You throw up the possibility that you did it, but that there wasn't a receipt received. It's not the error of law point, as Mr. Marek makes, but this is bound to be relevant to the degree of improbability of the individual's case that they didn't receive it, isn't it? It's bound to be relevant.
Yes, my lord, and that's why I've highlighted the second sentence of paragraph 15, is explaining why, in some circumstances, a delivery request may have been made, has been received, but nonetheless, the receipt confirmation doesn't come back. And in due course, my lords, I'll take you to the evidence, which we say shows that there's a very strong case.
So your evidence is going to be that despite us not having followed our own policy, and despite us not knowing what actually happened in the individual case so far as delivery receipts are concerned, it's a knockout case. That's what we're getting in a moment, is it?
With respect, my lord, that's not quite right. We don't accept that the policy was not followed. I have candidly acknowledged that we don't have a record of a receipt request having been sent. My instructions are that is because the system used to make records by the Secretary of State does not record the making of a receipt request. And so we cannot, from an evidential point of view, point to evidence that shows that a receipt request was made. My instructions are that such requests are made routinely.
Yes, you get a delivery receipt. If you've made the request, you've got a delivery receipt.
Well, that's why I've referred you to the second sentence, paragraph 15. That's not necessarily always the expectation. And in any event,
Yes, well, what you have to do, this is common on, as it were, it's out there. If you want to not send delivery receipts, you have to go to some lengths to tell your computer not to send delivery receipts. It's not a default position.
with respect, well, I can't help with that. I don't have evidence to assist on that point.
Yes, well, you can pick it up in a minute, as it were.
I'm great.
And there's common ground, there was no bounce back in this case.
It's common ground, and I hope I've been very clear about this.
Yeah.
That the evidence we have shows that the email was sent, but there's no confirmation that it was received. And the policy makes clear that there only needs to be a record of confirmation if one's received.
Yes.
So the implication is that one was not received, but that, what I've been trying to explain is that doesn't necessarily mean that a confirmation of receipt request is not sent. That would normally happen. It's just I can't point the court to the evidence that demonstrates that it did happen because of the way the Secretary of State systems in terms of making records operate, for better or worse.
Mr. Biggs, I'm sorry we're all asking you questions. I know it's difficult when that happens, but can I put a slightly different point to you? Are we all agreed about what a delivery receipt means?
Well, I'll tell you what I think it means, and you can tell me if you disagree. It's not something that's really been the subject of submissions by the party, so it may be that I don't have a firm grasp of it. But my understanding is that a delivery receipt confirms that the email has entered the email inbox or the appropriate email system.
And is it your understanding that that is a receipt which is generated automatically by the recipient's email system?
Yeah, well, subject to what's said in the second sentence.
Subject to that. So this is not something which the recipient has to do consciously. But if it's working, it's an automatic response showing that it's arrived in the inbox or in the address.
I think, given the position of the evidence, all I can say is that may well be right. My sense is that you can set up an email, a piece of email software to automatically send receipt confirmations or not. So it may be that you have some control over whether that automatic process whirs away, as it were, or not. And that's not something that's been explored in the evidence here. It may be, for example, that the appellant could have put in evidence saying, I haven't set this up, or I have set this up, or whatever. His evidence is silent about that. But, as I understand email software, there are a number of options that you can use to set up your email software. One of them, I know from personal experience, read receipts are optional. You make it clear that you opt in, if you like, to the read receipt confirmation. And it may be that the same applies to delivery receipts as well. I don't know. It's not something that's been addressed in the evidence.
This is not evidence, but I think you opt out.
That may well be right.
I put this proposition to you, see if you think it's right. If the delivery receipt had been received, that would be strong evidence on your case that notice had been given on your interpretation.
Yes, because it's been received in the way I tried to explain before lunch.
On your case.
Yeah. If Escobar's right, there would still be quite a lot that a person in that situation could try and say. But we'll say Escobar's wrong on that.
But if in the absence of a delivery receipt, the highest you could put it is the absence is neutral. It doesn't lead to an inference either way.
Well, with respect, under the statutory scheme, there's a presumption of notice, which the Secretary of State is fully entitled to rely upon. That's the scheme that Parliament has set up to deal with the
but I'm talking about the fact that there is no delivery receipt. Is that anything more than neutral on your case?
It might, yeah, I'm very grateful. Yes, it doesn't assist one way or the other, especially given what's said at paragraph 15 and the fact that there was no evidence from the appellant on this particular topic, no expert evidence, for example, looking at the position more broadly. This just doesn't seem to have featured in the way that the case was argued by the appellant.
I mean, there are a number of possible interpretations of what happened here.
Exactly.
It was never requested.
Yeah.
it never arrived. The delivery receipt mechanism was in some way disabled on the appellant's computer,
Yes.
or that it wasn't recorded. It was received, it wasn't recorded. I suppose that's possible.
That's not a possibility, but I would accept that the Secretary of State could be expected to record that in her systems, and she hasn't. So, yes, I accept all of those possibilities. But ultimately, the question is, in the light of the presumption of effective receipt that arises under 8Z A and B, and the principles set out in respect of that in Allen and Rana, in particular, what I characterise as a heavy burden that needs to be discharged to rebut that presumption. The question is, in the light of that legal framework and the evidence before the Upper Tribunal, was it open to the Upper Tribunal to say the evidence before the Tribunal was not sufficient to give rise to a realistic prospect of success? And I'll come to that very shortly. Before I do, can I just deal briefly with the Kelsey case that my learned friend relies upon? This is the judgment that was endorsed by the other members of this court of Lady Justice Lang, that my learned friend took you to before lunch. He relies in particular on paragraphs 74 and 75 on page 272. Can we just very briefly turn that up? Behind tab 11, page 272. Now, the first point to note here is that strictly, this case did not concern Article 8ZA and 8ZB. It was concerned with immigration rules that the court explained, I think, at paragraph 50 and 51. Adopted the same structure and approach to Article 8ZA and 8ZB. But be that as it may, in my submission, there's nothing in paragraph 74 to 75 that is inconsistent with the analysis I developed before lunch by reference to Allen and Rana and how, in respect of how Article 8ZA and 8ZB operates. What happened in this case, as I think my learned friend accepted before lunch, is that in the case of physical mail, an unauthorised interloper interceded to intercept a written notice that was on its way to the appropriate person affected. That can happen in the way I tried to explain before lunch, and as Lord Justice Floyd acknowledged in Allen and Rana. So this case, in my submission, doesn't assist my learned friend, or I would respectfully suggest the court in respect of resolving the question of whether Escobar was correctly decided on the point that I addressed before lunch, and the wider points as to how Article 8ZA and 8ZB operates. In resolving those issues, it's Allen and Rana all the way, with great respect. And after all Lady Justice Lang was doing in Kelsey was seeking to distill the decision in Allen and Rana and to apply it on the facts of that case. It's not entirely clear that there was a huge amount of argument about how that operated anyway. And my learned friend accepted before lunch that on this issue, the issue of whether there had been, whether there was an arguable case that there was an interception that meant that notice had not been received, that issue was actually not one that needed to be decided in any case because the appeal felt to be resolved for other reasons. So that's Kelsey. Turning then to the evidence. The first point I want to make is that the Secretary of State's evidence here is compelling and does lead to a very clear expectation that the email was received by the appellant. The first point here is the email itself, which is at page 18 of the supplementary bundle. All of the material I'm going to take the court to was in evidence before the Upper Tribunal.
Same one as page 95 of the main bundle.
95 is the notice itself. I've taken you, my lord, to the email under which
Oh,
the
I
notice
see.
was
Right.
sent. So
Yes.
it was an attachment, but yes, you're
Yes.
right.
Sorry.
What follows from page 19 and following is the same as we have at 95 in the
Yes.
So just looking at this email, you can see who the sender was, Home Office cancellations. So far, so good. You can see the date and the time. You can see the email to which it was sent, and the subject and the attachments. And as I've said, the attachments then follow. They're the notice to cancel and leave. We also have, as my learned friend took you through briefly earlier, the Secretary of State's Atlas records. They begin at page 31 and following of the supplementary bundle. The key parts are on page 32 and 35 and 36. So if we start with 32, you'll see towards the top under email addresses, there's the email address. That's the same email address that was used in that email we looked at
Yes.
on page 80.
Capitals, of course, rather than lowercase. That won't matter, you say.
No. It's not been suggested that it does, but it would. And if you're just pausing here, the appellant has accepted, as I understand it, that the evidence shows that the Secretary of State did send the email to this notice to the correct email address. On page 35, you'll see the evidence of how the email was, how the notice was sent, was dispatched. And around the middle of the page, you'll see a heading document track, and then a date and time. Document decision letter, that's the decision letter on page, I think it's 135 of the core, 19 of the supplementary bundle, the attachment to the email. Dispatch method, email. And then you've got a sort of summary of what that did under application decided.
Yes.
And then we've got a bit more detail on page 36, towards the top of page 36, the notes. Which just confirms what we've already looked at and that the email was sent.
Where would one find, for example, if you've got a bounce back?
That would, I assume, be recorded. I can double check, but it would be recorded in something like this note, presumably in this note. If my lord is concerned about the redactions, I've arranged for unredacted, an unredacted version of this to be provided to my learned friend. You can see nothing in the unredacted version that suggests that this version in the court's papers doesn't tell the full picture.
Well, I'd rather have expected it would be under document tract, which is on the previous page. That's the service element of it.
It may be, my lord. I can double check. I think the point is it will be in this Atlas record system somewhere.
Where is the delivery receipt recorded? If it's recorded.
Again, it would either be in the notes section or somewhere else, most likely, as my lord has suggested, perhaps under the document track section. But there would be a clear a record, and I'm told that if the document had bounced back, if the email had bounced back, that would obviously be recorded as well.
I have no idea what it means, but if you look at the shaded passage at the top of page 35, it says document tracked, last event.
Yes. I see that, my lord. I can't assist. I mean, I can't assist with that. There is obviously the next heading, document track, which gives details. It's not clear.
That document tract below the grey box is, as far as I see, last event document tract.
It may simply be a reference to the section document track, just recording that this event happened, but I don't know.
I mean, the last event is that the officer filled in the document tract section. It's referring to not some individual noticed what part of the document was last looked at.
I was probably
To
right.
help the next person to see where to pick up the thread or something of that sort.
I think that's probably right, Nora. And in fact, if you look at the bottom of page 34, so the top of this section, if you like, can you see it says last activity on 23rd of March 23 at 15:34, which is the same time as the document track section. So that's consistent with my law's observation.
But there isn't a box for delivery receipt on this form.
No, and that's, I mean, on instructions, I'm told that the system doesn't allow you to record that you've requested the delivery receipt confirmation. Only what would happen is that would be recorded in some way on this system if it's received, if the confirmation is received, and that didn't happen in this case because no confirmation was received.
Where would it be recorded?
I can take instructions, but it would be recorded. I mean, I know this is a unhelpful answer. It would be recorded somewhere on this system. Perhaps in the notes section. I mean, I would assume it's in that note text section on page.
It's in the note text section. There's no bespoke place that you're able to take us to showing where delivery receipts are dealt with. And it would be equally possible to record a delivery receipt having been requested in the note section as it would be a delivery receipt having been received.
I don't have any basis to gainsay that.
It would also be possible to have a box. I know we're here, three judges sitting here dissecting this computer program, which I dare say those who sit behind you have been tearing their hair out about, like all government computer systems. It's not perfect, but there isn't a box which says delivery receipt, which they could.
I'm going to turn my back, but as far as I know, no.
Please do.
And
That's what we understand, and I think instructions are being sought to double check. But with respect, what we see in the evidence is very clear evidence that the email was sent, the cancellation notice was sent to the right email address, the email address provided by the appellant, who doesn't dispute that he provided that email address. There's evidence to show when and how it was sent by email, and although there's no confirmation that it bounced back, that obviously is not of assistance to the appellant. There's no confirmation that it was received, but there might be reasons for that. See paragraph 15 of the summary grounds of defence. And so we say that the Secretary of State's evidential case leads to amounts to a compelling case that the email was sent, and in the ordinary event that entails compelling evidence, amounts to compelling evidence that the email would have been received. Now, against that evidence, all the appellant put in before the Upper Tribunal was a bare denial, albeit, I accept, of course, in the form of a witness statement. So leaving aside the new evidence...
What else could he do? I mean, this is what I don't understand. You say, well, there could be expert evidence, and you don't want thousands of trials. But what is somebody in this position to do?
Well, it's not for me to assist my own friend in his case, but he might, for example, have set out a detailed explanation of how much access he has to his email, what steps he took to check the email, whether there have been problems, technical or otherwise, in respect of receiving emails. He didn't do any of that. And for better or worse, we have the evidence to go on that he chose to put in on this. That evidence is at page 114 of the core. I know you've looked at it already, but if you'll indulge me, it's worth going back to it because it is very, very sparkling. The key passages are paragraphs 5 and 7 on page 115. As I did not receive any correspondence from the Home Office on the 24th of June, etc., and I'll come to that email in a moment. And then at paragraph 7, he reiterates what he said there. That, in my respectful submission, is clearly a bare denial.
Yes, but it's evidence that he acted on it. It's evidence the action he took is consistent with his not having received it.
It's
Getting the
evidence.
solicitor is what his case is. Getting his solicitor to write to the Home Office saying, where is it?
True, and I accept that, but it is evidence at a very high level of generality. He doesn't, for example, explain that he checked his emails. He might have been expecting to receive things by post, for example. So it's very limited evidence in my submission. We have the email, the letter of the 24th of June. That's at page 128, and I know my laws are interested in this letter. can I ask my lords to briefly turn back to page 128? And I think the second paragraph, beginning following the university notification, is the key passage.
Yes.
Now, what's striking about this is that it's actually inconsistent with the evidence my learned friend seeks to rely upon at the stage of relief.
You mean the point I made earlier about the skilled worker
Exactly.
tier 2 application sponsorship?
That's right, Lord. If you turn to that evidence, and in particular it's actually both statements that are inconsistent with that passage in the 24th of June email I've highlighted. But if you turn to the appellant's second statement at page 14 of the supplementary bundle,
Which we're still looking at the Bennett essay,
yes,
because you're objecting to its submission.
indeed, I'm well in the realms of a rhetorical point here. But if we look at page 15, paragraph 4, what the appellant says in paragraph 4 is really inconsistent with the picture he paints in his first statement and the passage I've highlighted in the 24th of June email. Because there, certainly in the email, he's suggesting that he couldn't obtain a new place of study without a 60-day letter. But he's putting forward a different case at paragraph 4. So there's only so much I can make out of this.
You say a different case. I'm not taking issue with what you say, but as a student, he was allowed to work in term time.
I would need to double check that. Yeah, so I think he was at Sheffield Hallam University.
That's what his visa says, and so he was perfectly within his rights both to be applying to a university.
You wouldn't need a
But
sponsor.
also to try and get a job.
As far as that goes, he was allowed to work 20 hours a week while studying. I accept that. But what he's explaining, I'm sorry, I've jumped straight to paragraph 4, but paragraph 4 needs to be read in the context of the statement as a whole, and paragraph 3 in particular. What he's explaining in this statement, and this is obviously very clear from the sponsor's statement, is that what he was actually trying to do was to switch into a skilled worker migrant visa. And that required finding a tier 2 sponsor. And he explains at paragraph 4 that he found out that he might be an overstayer because he did a right to work check for some reason in June, and then contacted his sponsor, and there was then some to and fro about COS, a confirmation of about apparently the tier 2 sponsor, which is explained at paragraph 3. And that's what, if you like, set the hair running and resulted in the appellant following up with the Home Office. But I'm entitled to make the point that that doesn't sit at all well with what the appellant explained in his first statement and what's set out in that first the email of the 24th of June. Now, there's only so much I can make out of all of this. But I add to that observation the fact that the appellant's own case is that he knew that he was not permitted to study. He had been, if you like, thrown off of his course from, I think, 2022, a date in 2022. So this is not an appellant who, from a sort of wider perspective, has been caught by surprise in terms of knowing that he needed to do something to regularise his immigration status. Anyway, there's only so much I can make out of the forensic points here. But the short submission is that the evidence before the Upper Tribunal was extremely limited, and as I'm sure my learned friend will accept, the burden was on the appellant to demonstrate that he did not receive the email.
Yes.
Now, when we look at the way that similarly weak evidence has been dealt with in the authorities, in my submission, it's quite clear that it was open to the Upper Tribunal, to conclude that there was no realistic prospect of the appellant succeeding at effectively trial in the light of the very, very spartan evidence that I've taken it to. And bearing in mind the Secretary of State's relatively cogent evidence that led to a clear expectation that the email would have been received. Escobar, at paragraphs 32 to 36, page 206 and following, involved a much stronger evidentiary case. where the appellant had at least put forward one possibility as to why he wouldn't have become aware of the email notice. He
Has
says
permission
that
been granted or not?
it had been, and
So this was after examination of the evidence.
well, I'm not sure exactly on what basis permission was granted, but permission was granted. I don't show away.
And there was examination of the evidence.
And at the substantive hearing, there's effectively a trial,
Yeah.
which would have to happen in these cases once you get past the permission stage.
So well,
So, but I am entitled to point out that Mr. Justice Sheldon was emphatic that the evidence presented by Escobar was very weak. That's not the expression he used, but he said, I think something like it didn't come anywhere near rebutting the presumption.
it says, felt well short.
So well, and great.
Sorry about that.
No, I'm very good. And as I say, the relevant passages are 32 to 36, where you
Doesn't come close to demonstrating.
very great. So, of course, with the benefit of hindsight, one might then ask why was permission granted, but that doesn't really matter. The point is the evidence didn't come anywhere near what it was required to. The other point
I'm not sure that's a legitimate way to put it respectfully. When you grant permission, you're looking at it in a certain way.
yes,
The fact that a case after the evidence goes completely the opposite way doesn't by itself detract from the decision to grant permission.
no, but we don't have the judgment on the grant of permission, and you have the observations that I've referred you to, which I do I respectfully submit I'm entitled to pray and aid in the way that I have. But I take my lord's point. Their permission was granted. The other point I would make there before I move on to deal with Alan and Rana, which was a permission decision, is that there was another argument that was before the court in Escobar about procedural fairness and the Anne Freever principle. And so it's possible that that was one indicator that there was an arguable case, even if the judge had some scepticism about whether the appellant, the applicant, the judicial review would be able to establish on the evidence that he could rebut the presumption of receipt. We don't know. More important is the case of Alam and Rana, because in Alam and Rana, this court was looking at an appeal from a decision to refuse permission to apply for judicial review made by the Upper Tribunal. And the evidence in Alam and Rana, in my submission, was, if anything, substantially stronger than the evidence before the Upper Tribunal in this case. There were two cases considered in Alam and Rana.
Should we go back to it?
Alam and Rana, yes.
Yes.
So the passages I'd like you to look at for Alam are paragraph 38 and 48 to 49. So 38 is on 194. So 38 is the summary, if you like, of the evidence in Alam. That wasn't sufficient to persuade the Upper Tribunal to grant permission. And at paragraph 48 to 49, Lord Justice Floyd upheld that decision. That's on page 196. Interestingly, the third possibility that Lord Justice Floyd identifies in paragraph 48 goes back to a discussion in the colloquy we had before lunch about the possibility of leaving a letter unopened or whatever in a property. Clearly, what Lord Justice Floyd is pointing out there is that that wouldn't suffice to show that the presumption of receipt was rebutted, which in my submission goes to support the submissions I made before lunch about the correct approach to isolate ZA and ZB. But for the purposes of the point I'm dealing with now, the short point is that the evidence that was summarised at paragraph 38 in Alam wasn't sufficient to give rise to that realistic prospect of success, even bearing in mind the need to take the evidentiary case at its highest. And the evidence in this case, with great respect, my lords, is if anything substantially weaker.
I'm sorry, I missed.
The evidence in this case, with respect, my lords, is if anything substantially weaker. Because it really is just a bare denial without any elaboration. Now, I appreciate that at 48, Lord Justice Floyd explains that the appellant's own evidence, Allen's own evidence, discounted the possibility of interception. But what Mr. Allen was saying effectively is, I didn't receive this thing, therefore something must have gone wrong. That's effectively the same evidentiary case that the appellant here puts forward, but with less detail. Rana, the relevant references are paragraphs 54 and 56. The evidence is set out at 54 on page 197. And you have the court's reaction to it, if you like, at paragraph 56, right at the end of the judgment, 197.
Well, yeah.
That really is that's the
That was
evidence.
recorded delivery with Royal Mail Track and Trace. Signed for something rather.
You see his evidence at 54, my lord. My learned friend sort of throws down the gauntlet here to me here, saying, well, you have to call my client a liar. Well, the same logic applies in respect of Mr. Rana and indeed Mr. Allen. Mr. Rana had specifically and clearly denied receipt, despite the evidence of receipt. Now, obviously, there are factual differences to a degree because we're dealing in this case with email rather than physical mail. But I've taken you to the evidence the Secretary of State says shows that there is a clear expectation that the email would have been received in the usual way. So, however one decides the points of principle that this case throws up, to my submission, the Upper Tribunal was quite correct to conclude that there was no realistic prospect of success in the light of the correct legal framework and the evidentiary materials before the Upper Tribunal. My learned friend took you to the Upper Tribunal's decision. I don't propose to go back to it unless that will assist.
Did the Upper Tribunal judge consider the point that the solicitor asking where's my letter of curtailment was evidence that his client hadn't received it?
There's no express mention of that, and I don't think the point was raised by the applicant from memory. It's not something that I have any recollection of having to deal with. I appeared before the Upper Tribunal. My learned friend, I should just deal with this point in fairness to Judge Leslie Smith, who made this decision. My learned friend says that Judge Smith made an error of law because she didn't appreciate the principles in Allen and Rana. But there's 2 points to make there. Firstly, that's not a sustainable submission in the light of a fair reading of Judge Smith's reasoning. And of course, Judge Smith was a very experienced judge, recently retired as it happened. The judge referred to Allen and Rana and heard submissions on it and made a decision in the light of the evidence. Where she refers at paragraph 4 to a bare denial, she's making the same point essentially as I'm making, that all the appellant had was a witness statement. He didn't say very much.
Well, the inference that I know you say it wasn't reliable, but the inference to be drawn, the fact that there is something from which an inference could be drawn, namely the solicitor's letter saying, "Where's my curtailment letter?" Doesn't that make it more than a bare denial? A mere assertion.
It's a bare denial that has some support from a circumstantial aspect of the case that could have been pointed to by an advocate. That's as far as it goes. I think when we stand back, my lords, we have to ask ourselves this with respect. If all the appellant had was the letter from the 24th of June and his brief witness statement of September 23 at trial, could he possibly hope to succeed? And just as in the Allen and Rana cases, the answer has to be no. He wouldn't have succeeded because of the presumption of receipt and notice. He had the burden of proof and he had to do more than his evidence did. But finally, just on this point about Judge Smith's reasoning, my learned friend has not pleaded a case that Judge Smith erred in law because she failed to apply the correct test. I just wanted to make that point to be fair to Judge Smith. His argument is that applying the correct test in the light of the evidence, the judge should have granted permission, and I dealt with that. My lords, unless you have any further questions, those are the points I want to make in respect to ground one. Can I very, very briefly deal with ground?
pause for a moment. I'm not sure you went to the facts of Mr. Rana's case. Because there's some slight interest in the context of this case. I'm looking at paragraph 50 of page 196.
Thank you.
And you remember that this was another student who had fallen out of his course. And if we read from paragraph 50, middle of the paragraph, that the college contacted the Home Office to report this. And the applicant then contacted the Secretary of State asking for a 60-day curtailment letter. And the whole case there was about the service of the curtailment letter. And then we see from paragraph 51 that it went into recorded delivery territory.
Yes.
And so forth. So one sees that asking for curtailment letters is not unique to this case.
You're quite right, my lord. I should have pointed out the clear similarity between Rana's case and the instant case in that regard.
So I wasn't myself drawing any
No, but with respect
conclusion from it, but just it was another instance where there was an issue about the service of the curtailment letter, and another issue in which it was the individual who was taking the initiative, apparently.
Yes, indeed. I mean, and as in this case, the appellant here was aware that he was no longer able to study for quite some time before the Secretary of State actually did something about it with great respect to my client by sending the March 23 letter. I'm grateful, Lord. So I should just deal with ground one briefly, because it does raise a point of principle which in my submission should not be resolved in the way that my learned friend says it should be. This is about the correct meaning of the word decision in paragraph 28(2) of the Upper Tribunal Procedure Rules. My learned friend says decision in that rule should mean legally valid decision. My submission is decision in that rule means a factual decision. And there are 5 very short points I want to make about that.
Just a minute. Just see how you put it in your skeleton.
It's in the supplementary skeleton where we do this, because I acknowledge that the key point in the case is actually ground 2, but in preparing for this case I did realise that it might be that the court wants some assistance on this issue.
So your point is, it means the factual decision and not the giving the notice.
Yes, and I've got 5 short points I want to make about that. They're encapsulated in the supplementary skeleton, but I think some of them are not made explicitly. So if I may, I'll just reel those off unless that's unhelpful. I'm conscious that this is not perhaps at the centre of the court's concern, but there is a point of principle here which I don't want to lose sight of with respect. So, my lord, the first of the 5 points that I just want to make is that looking at the ordinary language of Rule 28(2), it's clear that the rule is referring to the fact of a decision rather than the legal validity of a decision. The second point, and if you want to look at it, the text of the rule is at page 90 and following. In the
Thank you.
authorities. Page 90. 90.
Thank you.
So ordinary language supports my submission. Second point is that it would be anomalous otherwise, it would lead to strange results otherwise, because of course it's often argued in proceedings for judicial review that a decision is not legally valid. So if it meant a legally valid decision, there might be an argument that actually time never begins to run at all, which would be strange. Thirdly, our submission as to the correct interpretation of 28.2 actually reflects the settled practice in respect of time limits for judicial review in the administrative court. And in the interest of time, I won't take you to these authorities, but I'll just give you the references.
I think you've got to, Mr. But this strikes me as a very important point, potentially. If you're saying that a judicial review claimant in a case such as this can be time barred in respect of a decision which hasn't been published at all, then you've got to make that good on the authority.
I'm very grateful, and I will, but let me just make this clear. As the case I'm about to take you to also makes clear, there's obviously always the possibility of a discretionary extension of time, and it's at that level that issues about notice and becoming aware of a decision would then be relevant. So the settled practice is my third point, that our interpretation of Rule 28.2 reflects the settled practice in respect of judicial review in the administrative court. And that, there are 2 points to refer to you to here. The first is the Pressback case, which is tab 14, page 305. Pressback. You've got the head note at 305 at G. But the key reasoning is internal 133, line marking D, to internal 134, to line marking C. So that's 133C, sorry, 133D to 134C, pages 317 to 318 of our bundle. I'll just summarise the import of those passages. For the purposes of the predecessor to CPR 54.5, which is the time limit rule for judicial review that currently is in place, a decision, time starts to run not from the date of notice of a decision in the sense of becoming aware of the decision, but from the date of the decision. But whether to extend time, when considering whether to extend time as a matter of discretion, the fact that the decision didn't come to light, as far as a claimant for judicial review is concerned, is a highly significant factor when it comes to the extension of time. The second port of call here is the Administrative Court Guide, which I think you may not actually have. We did file an amended electronic bundle a couple of days ago, which has the right version in it, but I've got hard copies here. Perhaps I'll just give you the reference because you can find it pretty easily, and we'll hand these up. This point about Pressback is reflected at paragraph 6.4.2.2 of the Administrative Court Guide, the current guide, which says this: where the claim challenges a decision, the time limit begins to run from the date of the decision to be challenged, from the date the decision to be challenged was made, brackets, not the date when the claimant was informed about the decision. And then there's a footnote that cites Pressback.
Yes, but it all depends, doesn't it? I mean, Pressback is a case where some regulations were made and the corporate claimant said, well, we weren't aware of them.
Well, can I deal with the it all depends point, because it's my fourth point. My learned friend says, well, in the context of Upper Tribunal, the Upper Tribunal's judicial review jurisdiction, there's a ready reason why you should interpret decision in the way he says you should, valid decision rather than factual decision, because of the way that Section 4.1 of the 71 Act operates. The answer to that is twofold. Firstly, that the same arguments have been made in respect to the administrative court, so in respect to 54.5, in the light of the Annie Freever case, the case about the constitutional importance of an administrative decision being communicated to a person affected rather than not being communicated. You can see that argument being made in the decision of Mr. Justice Chamberlain.
Before we go away from the administrative court guidance, could you just, I'm just having difficulty in situating this argument in the facts of this case.
Yes.
So what that paragraph says is that the time limit begins to run from the date of the decision to be challenged. So the date the decision to be challenged was made, not the date when the claimant was informed about the decision. So in this case, how does that play out?
Well,
What are the competing dates?
The decision in this case was taken on the 23rd of March. It was actually 2023. If we're right, if the Secretary of State's right, then the presumption that arises under the statutory scheme is that it was validly notified on the same day. My learned friend wants to say, no, it was not validly notified until 20th of July 2023, which is when the letter was resent on our case, attached to the second pre-action protocol.
Decision being made, you mean made and communicated, because that, in this context, it's the receipt, as it were, of the decision in the approved place, whatever that might be, that amounts to the legal decision. You're not saying when it was made on our desk and not sent.
For the purposes of Rule 28.2, my submission is that decision means factual decision. It doesn't mean legally valid decision.
If you're right, that no letter needs to be sent at all. Just note to file, we're going to curtail this guy's leave, but they forget to send it, say. You say time begins to run, and if the claimant concerned only learns about it 4 months later, well, that's too bad. He's still got to apply for special permission to bring the case out of time, and this is.
The point, my lord, is that the word decision in 28.2 means factual decision. It covers obviously a wide range of potential decisions, some of which it might be said are not legally valid until they're actually notified or until there's receipt or whatever. The way that operates is that it would be incumbent on the applicant for judicial review to seek an extension of time. I accept, though, that if the applicant were able to demonstrate on the evidence that he has a realistic prospect of showing that there was no legally valid decision, that would be highly relevant to the extension of time that the court would have to engage with. But the difficulty with my learned friend's submission is it has broader implications. It doesn't just apply in cases like this. It would potentially apply across the board, so that it would be open to someone to say, well, I am in time in my respect to my claim for judicial review because a decision is not legally valid for some reason. And in my submission, that is not.
It's not to do with legal validity, it's to do with communication. That your submission seems to be that time starts running from the moment of an uncommunicated decision, which uneducated, I would thought, can't possibly be right.
Well, if you're of that view, then I will lose on this issue. Can I just refer you to a couple of more points? But
sorry, I don't mean to be glib about it, because I do quite agree so far with your submission that whether or not it's a legally good decision, it can't possibly be the test for when time starts to run. As you say, that's to beg the question in the.
I think, my lord, the formulation in the administrative court guide, my lord, that you put to me is obviously not the statute, is not the relevant test. The test in Rule 28.2 just refers to the decision. It doesn't say when a decision is made. What the guide is doing, and the reason I've referred you to the guide, is to say actually these arguments my learning friend wants to make could be and have been made in the context of the judicial review time limit that's applicable in respect of the administrative court. And for that, I just wanted to refer you to paragraph 68.
Yes, was this the extract from the guide which we haven't got,
yes,
but you were going to hand up?
Yeah, I'll hand it up now. I'm sorry, it's a bit cumbersome, but if you want, you can insert it into the authorities
Yes.
at tab 4,
Yes.
at page 262
Will do.
and following. I've line marked a rather long paragraph number that I referred to. So as I say, this is just for the point that the same arguments my learning friend wants to make here would apply in respect to the administrative court, and for the point that the administrative court adopts a practice that's the same as that which the Upper Tribunal adopted here in respect of Rule 28.2. So, my Lords, I've referred you to paragraph 68 of a case called Inclusion Housing Community Interest Company and Regulator of Social Housing. That's at page 223 of the authorities, tab 10. Tab 10, paragraph 68 is at 244. And this passage, I think, makes good the point that the argument my learned friend is making in respect of Rule 28.2 of the Upper Tribunal Procedure Rules is also available in respect of CPR Rule 54.5. But that point has not been accepted to date. The settled practice is the press back practice, if I can put it like that. It's consistent with the Administrative Court Guide.
Sorry, which paragraph in inclusion housing should we?
68, my Lord.
68.
244. For those using electronic. Behind tab 10. So this is essentially the same argument that my learned friend makes, and Mr. Justice Chamberlain, obviously extremely experienced judge, makes the point that it's, if you like, an argument that's floating around in the administrative court too. So the reason I highlight this is because my learned friend suggests that Rule 28.2 should be interpreted in the way he says it should because of the peculiarities of immigration law, but that argument doesn't work because the same analysis, essentially, mutatis mutandis, could be applied in respect of CPR 54.5.
Yeah,
so
but I mean, the argument against you, I think, is it all depends on when the decision occurred. And the case law that Mr. Malik referred us to, Mahmood and Ahmadi, show that the decision isn't made until notice is given.
That's right, but again, that brings me back to my formulation. It's a factual decision rather than a legally valid decision. I mean, in a factual sense, there has been a decision taken. The question is it legally valid under the statutory scheme? Now, I appreciate that it's to a degree unattractive to say that a decision that hasn't been communicated triggers the time limit, but the way to deal with that without doing, with great respect, inappropriate damage to the clear language used in 22.8 against the clear practice following pressback in the administrative court, is to acknowledge that when the Upper Tribunal comes to consider whether to exercise its discretion and extend time, the fact that it's being said that there's an arguable case that the decision didn't have any effect.
This cannot be right. The whole point of time limits for bringing applications for judicial review are to make people act promptly in protecting their seeking a remedy if they feel they've got one.
Yes.
And so how can that possibly work if they don't know that there is a decision from which they need to be remediated? Why should a person in that situation be having to ask as a matter of discretion for the right just to put in a claim, not necessarily going to get anyone, but put in a claim which they would have a right to do within the time period? It's converting something that they're entitled to of right to something that they can only do by grace of the court. There's no answer, is it?
Well, of course, judicial review is a discretionary remedy, but
the court doesn't have a discretion not to receive an application for judicial review. What you're talking about is the court saying, we're not going to receive this application for judicial review because it's out of time. Is that the difference between the two?
Well, the way this would operate in practice, my lord, is that an applicant such as this appellant would have to come to the tribunal and explain how he acted promptly in circumstances where, in this case, he was told in response to the 24th of June pre-action protocol letter that there was a decision, but he said that he didn't receive valid notice of it. At that stage, he could be expected to come to the Upper Tribunal and pursue his claim for judicial review. He could have done that. He didn't do that until September. All this point of interpretation does is require an applicant for judicial review to explain why, as a matter of discretion, time should be
Yes, but
extended.
I appreciate in this case you can make the point about what happened to the summons, but your argument would have applied if he'd sought judicial review the day after he was told in June. Your argument, if it was correct, would be, well, you're out of time. You have to go to the administrative court and seek.
23rd of March was the date of your decision. 24th of June was if he told you on the day he got the next day, still out of time.
Yes, he needed an extension of time.
Doesn't this involve a fundamental right? And if it involved a fundamental right, why doesn't the principle in Amifrajaja, if that's how you pronounce it, apply? Namely, that it doesn't take effect. That's the origin, as I understand it, of the Ahmadi name Mahmood.
Not quite with great respect, because
Well, I mean, I'm sure you know.
well, it's how Section 4.1 operates, as my learned friend explained by reference to paragraph 22 of Ahmadi.
Yeah.
Section 4.1 is the mode by which the cancellation of leave is brought about.
Okay.
So it has to be given in notice before it has legal effect. My lords, I understand the court's concern from a perspective of sort of wider justice, that it's potentially unfair for the time to start to run from the date of a decision where that decision is not known to the person affected. But all I'm seeking to do is to, if you like, remind the court that that has been the law in respect of the administrative court since Pressbeck. In that, this suggestion that, in the light of Anna Freever and just justice generally, it would be unfair to treat the time limit as beginning from the date of a decision that someone didn't know about. It has been an issue since the Pressbeck decision. As Mr. Justice Chamberlain indicates at paragraph 68 in the case I referred you to, page 244 of the authorities.
He doesn't exactly
He leaves
come down firmly on your side of the fence, does he?
no, he doesn't, my lord. But all I'm saying, and my lords, it's a matter, of course, for you to decide this point.
Yeah.
I'm simply highlighting that this is not a point of small importance, given that it does. The Secretary of State's position is, and the Upper Tribunal judge's decision here, to be fair to her, simply reflects the settled practice since Pressbeck.
Well, it's settled with some exceptions, which we haven't gone through in the guide.
Well,
And
the guide, the general position in the guide is based on Pressbeck. There are other time limits that apply to certain types of judicial review, if you like, but we're not in that territory here. Rule 28.2 is effectively the equivalent of Rule 54.5. 54.5 is what the guide refers to in the passage I highlighted. My lords, those are the submissions I wanted to make. Effectively, on ground one, this point about what 28.2 means, I simply want to make clear to the court that there is a wider point of importance which has perhaps vexed public lawyers for some time. And I, with great respect, wanted to point out that if the court was going to grapple with it, that should be acknowledged. There's my submission. I mean, it doesn't really matter here, I don't think, because although my learned friend hasn't really argued the case this way, I can see the argument that if he wins on ground two, then the judge's exercise of discretion is unsustainable. But if he loses on ground two, obviously his argument
This doesn't matter anyway.
so are you sort of saying to us, don't go there,
I think
judges, because it's a very complicated issue, and we don't have to decide it. Well, we can decide it all on ground two. If we're with Mr. Malik, the UT judge's decision can't stand, and if we're against him, then ground one is irrelevant.
I certainly endorse the force of that approach. And to be fair to Judge Smith, I just wanted to emphasise that all she did in respect of the timing question was to follow what's effectively settled, well understood practice in respect of administrative law. My lords, unless you have any questions, there's my submission.
there may be a situation where it's not necessary for this court to embark upon an issue, give a view of an issue, where the High Court, the Upper Tribunal, whatever, has said something that might resonate in other cases. But in this instance, the permission decisions of the UT are not precedential, are they? They're probably not citable. So even if there was some doubt about what was said by the Upper Tribunal, it wouldn't be necessary to correct in a sense, because these were permission decisions.
Yes, and I mean, I can't make any concessions, but on ground 2, as I've acknowledged, if you're with my learned friend on ground 2, I respect firmly submit you shouldn't be. But if you are, then I can see the force of the argument that my learned friend makes. At that stage, the Upper Tribunal's consideration of the question of discretion as to whether to extend time would have to be revisited.
Yeah.
Unless I can assist you further, my lords.
Very grateful. I'm struck by the fact that in most, though not all, of the decisions cited to us, either Mr. Malik appears or you appear, and in Lord Justice Floyd's case, you were for the appellants, and in Kelsey, Mr. Malik was for the Home Office, as indeed he was in another case before me a couple of weeks ago, and that you both, if I may say so, reinforce the theory that people who are not always on the same side of the fence argue cases that much better. We're very grateful to you. Mr. Malik, anything to say?
Just very brief submissions in reply. So on law, you'll recall that my learned friend advanced 4 propositions. His first 2 propositions are with respect entirely correct. Proposition 1 is sent creates a presumption. Proposition 2, given means receipt. Proposition 3, he says that receipt should not be given a narrow meaning. And my lords will recall that my learned friend started his submissions by saying that receipt means arrival at someone's inbox. But he then sort of modified that answer and accepted quite properly that sending an email is not conclusive proof of receipt. And he then also quite fairly accepted paragraph 30 of Asylum that interception with correspondence may occur after delivery at the relevant address. Lord Justice Floyd said that in my submission categorically at paragraph 30 in Asylum when he says the mail so arrives is intercepted. So as modified, I don't have a problem with my learned friend's third proposition as well. My learned friend's fourth proposition is that there is a weighty burden on the appellant. At permission stage, there is no weighty burden. The burden is to show that there is a case that is capable of belief. It's not hopeless. At a substantive stage, the burden is to show on balance of probabilities that presumption is rebutted. Learned friend used the phrase bright line rules consistently in his submissions on law. If you look at the legislation makes a bright line in relation to giving of notice by hand and makes it absolutely clear that there's no question of presumption that arises. But no bright line arises is in the legislation about other methods unless contrary is proved, is what the legislation says. no doubt with respect that that isn't a bright line rule. A rule that creates a presumption, a rebuttable presumption, is not a bright line rule. On the facts, Melanchthon says that the Upper Tribunal was right to find that this case wasn't even arguable, but it's the combination of 5 factors that I identified in my opening make this case strongly arguable. First, the appellant's evidence in his witness statement. It's not a letter, it's a witness statement. Second, the letters from solicitors dated 24th of June 2023 and 6th of July 2023 support his evidence. Third, no immediate apparent motive for the appellant to lie in the evidence. He's someone who knows the consequences of overstaying. If he had received the notice, it is inconceivable in my respectful submission that he would do nothing about it. Fourth, the Secretary of State has there is no evidence that the Secretary of State sent a delivery request, delivery receipt request, and there is no delivery receipt. It's not conclusive, of course, but surely relevant. Melanchthon accepted in his submissions quite properly that delivery receipt is generated automatically. So the fact that there is no delivery receipt is surely relevant. And fifth and final point, I've taken you to the records, in particular the records that appear at page 32
In the supplementary one.
in the supplementary bundle. The email address that the Secretary of State sent the document to, the records say that it is not verified, it is not contactable. You'll see contactable, no; verified, no; email address verified, no. And this is not the primary email address. So this isn't an email where, for example, the Secretary of State has previously sent an email from, or
No dispute that is the correct email.
there's no dispute that that is the correct email. But the point is that there is no evidence that that email was previously used by the applicant to send correspondence to the Secretary of State or the Secretary of
There's
State.
no track record of it being used as a means of communication between the Secretary of State and your client.
And that's why the records say that it's not verified or contactable. Combination of these 5 factors surely means that this is not a hopeless case. The appellant's claim is capable of belief. It must be taken at its highest. And he, in my respectful submission, is entitled to a trial. He may win, he may lose. That's a question for the fact finder. It cannot be said that his case on facts is hopeless. In response, Melanchthon makes 2 points. First, he says that there is inconsistency in the letter from the solicitors that was sent and the appellant's second witness statement. It is the point that Lord Justice Baker noted when I was making my submissions in opening. I mean, I was reluctant to grapple with the point head on because it is a point of fact. And my submission, my lords will recall, was that it's essentially for the fact finder to decide whether there is inconsistency, and if there is, whether it is material. But given that Melanchthon has made a positive submission that there is inconsistency, I just feel obliged to make a submission that there is no inconsistency. So the solicitor's letter is at page 128 of the bundle. And it is the second paragraph that Melanchthon cited. The letter is written in June 2023. it says that the applicant tried his best to reach a different provider. However, her current visa conditions only enable him, says her, to study at that particular university. Our client has informed that since he has not received the curtailment notice, he cannot be given the confirmation of acceptance for studies. That's what that letter says. It is not inconsistent with respect with his second witness statement. Now, of course, I took you to the paragraph in the second statements that were directly relevant to the question that you asked, but I do ask you, given the submission that my learned friend has made, to if you go to page 11 of the supplementary bundle and see paragraphs 1 and 2, he explains that he had tier 4 leave. In September, there was an issue surrounding to the course. He was de-enrolled. He tried his best to reach a different provider. However, the visa conditions only enabled him to study with that university.
Where are you reading from now, sorry?
Page 11 of the supplementary bundle, paragraph 2. So you don't, with respect, of course, look at the next paragraph 4 in isolation.
For some reason, the sponsors and your client's statements have been put around the other way. So let me get paragraph 2. Actually, on page 14 in my book.
No, Lord, if you go to page 11 of the supplementary bundle, page 11.
Yes, in my supplementary bundle, that is the sponsor's statement. Your client's second statement
Mine
is
too.
page 14.
Anyway, it's your client's statement,
So
paragraph
sorry,
2 that you
no,
want.
so- yes.
We didn't get onto the sponsor's statement. I dare say Mr. Bigwood have made some points about that.
So paragraph 2 of the appellant's statement.
Yes.
So this is entirely consistent with the letter. He then explains that, well, I wasn't able to enroll at a different college. My friends are getting this visa, and I thought that I would do that myself. So when you read paragraph 4 in that context, there is no inconsistency. Or put another way, if there is inconsistency, it isn't a knockout point to hold that, well, the claim fails for that reason alone. The second point that my learned friend makes is that he asks you to compare the facts of Alam and Rana with the facts of this case, and he makes a submission that, well, permission was refused in those cases. The evidence there was much stronger, but that surely cannot be the case. All, my lords, you have to do is to look at paragraphs 40 and 51 of the judgment to know why that is so. So tab 7 of the authorities bundle, page 196, paragraph 48. Paragraph 48, 3 possibilities. The court was satisfied that notice had in fact been delivered. That is possibility A. The court cannot be satisfied here in absolute sense that the notice actually reached the appellant's inbox. Second, the notice had been intercepted by a flatmate. That wasn't the case. Mr. Alam did not suggest so. And the third possibility was that the notice had been delivered, but Mr. Alam has not looked at it or left it unopened. But completely different case. And when you read the rest of the paragraph, you'll see that that is completely different factually. And more so is the case of Rana, my lords. If you look at paragraph 51, not only there was a delivery receipt, a recorded delivery number, there was a recorded delivery number which is sort of equivalent to a delivery receipt digitally. Then you'll see that someone received that, and that the person who received signed the document saying Rana.
Yes. we've got that point, Mr. Dhandapan.
So nothing in that can possibly, in my respective submission, answer the point. And then just finally, Miller and Friend made submissions on the meaning of word decision and the time limit when to bring a judicial review claim. In my say this with respect and diffidence, the submission is an extraordinary submission. I mean, it leads to, in my submission, obviously insane consequences. The court cannot possibly accept that submission. It cannot be right that the Secretary of State makes the decision in her mind one day, but decides not to communicate. And the time limit to bring a judicial review claim starts running from that date. Accepting that submission will turn things upside down in this jurisdiction. So word decision is used in the rules not only in relation to judicial review, but also when it comes to appealing from the first-tier tribunal to the upper tribunal, and then from the upper tribunal to this court. I mean, what if a judge in the first-tier tribunal hears the appeal, makes a decision in his mind or her mind that, well, I'm dismissing the appeal, but then goes on a holiday for 1 month, and then after 1 month promulgates a decision? It's just insane to suggest that the time limit starts from the date on which.
I would never describe Mr. Biggs as insane, but I don't think we need to hear you on this point. Speaking for myself, I don't see that PressVac has got anything to do with this case.
So, not suggesting that Mr. Biggs is insane or his submission was insane. I'm simply pointing out that the consequences are extraordinary.
There are cases of case I did a few years ago called D4 comes to mind, where things happen and it's seriously maintained that notice to file. Do you remember that case?
Yeah.
Remember there was a distinguished judge who dissented in that case.
Yes.
I wouldn't call him insane, Mr. Mack.
Yeah. But we're not in that territory. Now, just one final point on this about the extract from the handbook that Miller and Friend handed up, which says that the time limit to bring begins run from the date of the decision to be challenged was made. I have no problem with that. The binding authority is that a decision is made when it is communicated, when it is served. In Mahmood, the Secretary of State had made a draft decision on the file, but that wasn't communicated. So a decision is, I have no issue with this. A decision is, the time limit to bring a judicial review claim starts to run when a decision is made. But a decision is made as a matter of law in this context when it is communicated.
Is there a general proposition as to when the making of the decision requires the giving of notice? Is it fundamental rights or is it ad hoc? This is in this case, but not other cases.
Yeah. So in this jurisdiction, unless a decision is communicated in writing, there is no decision at all.
What do you mean by this jurisdiction?
Sorry, in immigration and asylum jurisdiction. Section 4 of the 1971 Act says that categorically that the power to grant leave shall be exercised by notice in writing. So what the Secretary of State cannot do is to utter words, is to say orally that, well, I'm granting you leave. That's not leave. Unless
Grant, vary, rescind, revoke. Whatever.
Precisely.
Yes.
And this a fundamental feature of the fundamental aspect of immigration asylum jurisdiction that distinguishes it from other areas of law is the obligation on the decision makers to produce written decisions together, not only a decision, but together with an advice and notification as to appeal rights. So this obligation rests not only on the Secretary of State, but also on the first-year tribunal. So when the first-year tribunal dismisses an appeal or allows an appeal, the tribunal is obliged to do that in writing and then advise the appellant that there is a right of appeal to the upper tribunal, advise the appellants of the time limits and how the appeal is to be brought and the facilities that are available. Same applies to the upper tribunal. When the upper tribunal makes a decision, it must be given in writing, and then that decision must contain advice about appeal rights to this court. That is the reason when you see in this jurisdiction decisions of the tribunals, you always see towards the end of the decision a heading notification of appeal rights, and under that heading there is always a notification as to bringing of the appeal rights, etc. Well, for example, see page 53 of the main bundle. This is required by the legislation and the rules. Unless I can assist you any further, these are my submissions in reply.
Very much, Mr. Malik. Thank you both for your considerable assistance. We are going to reserve judgment. We hope not for very long. Should we not be able to send out the draft decision by the end of July, and if either of you is going to be on holiday, which you have every right to be, would you notify the court office immediately of who can be the alternative point of contact for receipt of the draft judgment? The draft judgment, as you know, is not for re-argument, but for correction of typos, factual errors, and so forth. And its contents are confidential to the appellant on his side and those who need to know in the Home Office on the other side until publication. We would hope that the terms of the court's order can be agreed. If not, any submissions to be in writing. I think that covers everything. Thank you both very much indeed.
Court rises, please.
Okay.
Made the point, but not
Can I please remind the quorum that the live stream is recorded despite the screen?
Yes.
It's 3 months starting. From the date the tribunal